Hi, everybody. Happy Tuesday. I'm Madelena Viksne from Samfiru, Tumarkin, and I am an employment lawyer working in BC and Vancouver. I'm sorry, BC and Ontario. Um, and I'm just here today to answer some employment questions if you have anything that you were wondering about. In the meantime, I thought that I would talk about a recent decision wherein a 35-year employee was awarded $170,000 in severance after 35 years of service when the business, which was Cathay Pacific, shut down its Canadian operations. Um, so what that sort of brings to mind is a number of questions that I've been getting lately are what happens if my company shuts down? What happens if my company's sold? And what happens if my company goes bankrupt? What happens to my entitlements? Um, or if I'm terminated as a result of those things. So there's a couple pieces to that. Um, if your company goes bankrupt, then it's likely that you won't receive much of anything in the event of termination. Um, you can be considered a creditor if you have already started litigation prior to the bankruptcy. And you also may still receive your Employment Standards Act minimums. But beyond that, it's unlikely that you would recover anything. If you've started litigation and you are hearing rumblings about that, it might be a good thing to let your lawyer know um, so that they can potentially sort of fast track any settlement discussions that might be happening. Um, in the event that you do receive something as a creditor, you're often getting only cents on the dollar, um, anywhere from a couple of cents on the dollar to 75% of like to 75 cents. So you should just be aware that that is a risk in the event that your company goes bankrupt. And there's not really much in terms of legal avenues for us to continue to assist at that point. So definitely let us know. In the event that your company is sold, it depends on what type of a sale it is. Oftentimes, there will be a agreement between the purchaser and the seller in terms of what they want to have done, what they want to have be done about employees and recently terminated employees or those who are on layoff or so on, where there might be future liabilities. There's a number of different options. It really depends on what's negotiated, but one of them is that the prior employer remains responsible for the severance, um, and therefore terminates you at the time that the business is transitioning. More often, the new employer will sort of take on your employment themselves, and if that's the case, it's possible that there's an agreement in the background where there's almost like a money pot or a deposit that's been made as part of the sale agreement to help cover some of the costs of any employment liabilities that could arise from continuing employees. But it's the new employer in those scenarios who is technically responsible for providing you with severance if you're terminated because your employment has been transitioned to them. Yeah, so those are sort of the two things that I thought would be helpful because there are a number of sort of questions happening, um, just generally about what's going to happen when a company potentially is sold or shuts down, or like the tech sector right now, where there's sort of talk of either layoffs or a slowdown coming. So if you have any of those situations take place, feel free to call us at the number on the screen. We'd be happy to help or speak to you about your issues. So I have a question from Sandra via email. My employer sold the company to a relative and wants me to sign a new employment contract after 7 years with the company. Do I have to sign? Um, it depends in a way as like whether or not your employment has been transitioned. Is it the old employer or the new employer who's asking for the contract of employment. Were you terminated by the previous employer at point of sale and then rehired, or is this a continued employment situation? It may be that the contract doesn't restrict your rights as much as it may seem. It may seem unusual that you'd have to sign something, but you'd have to remember that your prior employment contract, it determines the terms of your employment with your previous employer. Now, those terms can be continued on. You could be continued on subject to the same terms and conditions as you've always enjoyed, but the new employer may have some other terms, may have some other ideas about how they go about managing their employment contracts. So it might be a good idea to have an employment lawyer take a look at it. If you didn't have an employment contract written before, then obviously we know that it's going to have some restrictions on your rights that you didn't have before. If you did have one before, it would be a good idea if you do decide to contact us to have somebody review it, to have both the new one and the old one together so we can explain to you what the difference is, and just sort of give you some advice about what the change would even mean. I wouldn't outright necessarily refuse to sign it before having it reviewed, because it may be that it's just sort of a battle that isn't worth fighting, if the changes just really aren't significant. But in any case where you're already an employee, so this is assuming that you weren't terminated by the old employer and rehired as a new employee. But in any cases where your employment is ongoing, you don't have an obligation to sign a new employment contract. Now, an employer can certainly take action if they don't like that. They don't have to continue to employ you, but it would be a without cause termination. Um, so, if you refuse to sign, I suppose it's possible that the offer could be pulled. Um, Generally speaking, though, just across the board, if you're given a new commissions plan or you're given a new employment contract at any point in your employment once you're already working, there is no obligation to sign it, and you can't be forced to sign it. It's just that if you refuse and the company chooses to, they may decide to terminate, and if that's the case, then they would owe you severance for that. Sorry, I have really bad allergies right now. Okay, Anne Marie from Facebook said, "I've been off for 8 months on short-term disability, and I'm now on unpaid leave of absence. I will return to work next week. I was off due to workplace stress from a bully boss. I will work for the same boss. I've opened a file with HR. This is not the first complaint about her leadership style. 8 employees have left in the past 5 years because of her bullying. When I go back, can I ask to be packaged out? They've hired someone to replace me already." Um, I'm Anne Marie. I'm sorry to hear that that's been going on with you. Um, there's a there's a couple of options I think that I see here. Um, One would be to go to your doctor and get some kind of a note that says, you're ready, willing, and able to return to work as per, the plan. But the idea of working for this individual directly is causing, my patient considerable distress. I don't see that as being a safe or productive environment for her. And so she will require accommodations, which involve ensuring that she's not scheduled working directly for this person, or that there's some safeguards put in place. Um, you can certainly ask to be packaged out. The employer doesn't have to package you out, and it will give them an indication that you don't want to be there, which might sort of change the trajectory of what's going on for you at work if they're looking to move somebody along or move them up a bit. Um, Through the company via promotions and so on. If you've expressed an interest in not being there, you may not be considered. I think if you went, you'd have to really explain to HR, what your basis is, for it to be the most productive conversation that you could. So, I've been off for this amount of time. I'm still feeling extremely anxious about working for this person. If there's nothing else that can be done in terms of, having me report to someone else directly, or like a transfer from your position into, into another position, which maybe you could negotiate based on the fact that you say they've already replaced you. Um, if if you can speak to HR about any alternative options, you could put in the packaging out as an option there. Um, I think it's important that you continue to communicate with your doctor and communicate with HR via doctor notes as well. Um, you could try returning to work for a short period of time and see how it goes. And if just the idea of going and going for a couple days is too much, then again go to your doctor and get a note saying, this is the situation. She was on the mend and now she's sort of fallen back again. I feel strongly that that has to do with the fact that she continues to have to work with the person who was the cause of her stress. Um, these are things that she's expressed to me would be useful for her. And then you're asking for an accommodation. So if they refuse to provide you with the accommodation, which they're required to on the basis of disability, then you could potentially have created a situation where there could be a constructive termination claim on the basis of the failure of the duty to accommodate. It's tough to say. I mean, I think that it would be worthwhile having a conversation with HR whether or not you're talking about being packaged out, or whether you're just talking about how the transition back into work is going to work while you're seeing this person on a daily basis, and just reinforcing that this person was and your interactions with them were a big cause of your stressors. You want to be there, but you just can't function in that environment, and find out what they come with solutions, not problems, but also find out what their advice might be or what their thoughts might be in terms of what could be done. Email question from Mo. I was terminated about 18 months ago without cause. Is it too late to go after severance? I've not found another job. Hi Mo. It's not. I would say call us like today. You have 2 years from the date of termination to pursue any sort of case, as long as you didn't sign a release at the time of termination. So I'm presume based on your question, but I could be wrong, that on termination you received a termination letter that only contemplated your employment standards minimums and didn't offer you any additional amounts to sign a release. You never have to sign a release for only your statutory entitlements. There are certainly tricky ways that some companies will try and imply that in order to get any amounts you have to sign. That certainly is not the case. If it is your 1 week per year up to 8 weeks of notice, or severance entitlements under the ESA in Ontario, those entitlements exist regardless of anything else, and cannot be tied to you signing away your rights. So those had to have been paid. So just assuming that they paid those on termination and didn't sign anything, it may be possible that you have additional entitlements and you have 6 months. But please call us sooner than later. Do not call us, a week before. It makes it very difficult for us to understand your case and best represent you when we don't have sufficient time. So I would suggest calling in the next couple of weeks. Bring your send your termination letter, send any contract that you had with that company, and somebody can meet with you during a consultation and take a look and let you know sort of what your entitlements are, and you could decide whether it would be worth moving forward. Matt from Facebook asked, after 3 years, I was terminated for not being a good fit. I just had an excellent performance review and a raise last week that then terminated without notice or cause. Can they do this? Yes. So just 1 second, everyone. Sorry. Sorry about that. My nose is running like crazy. Okay, so terminations for not being a good fit or without cause, without any reason. It's a bit of a misconception in Canada that your employer has to have a reason to terminate you. I get this a lot. I was terminated without cause, but there was no reason. I was great at my job. There were no complaints. Um, and I appreciate that that's very confusing, and can be really painful, especially when it wasn't expected. The issue is that in Canada, you're not required to be provided with a reason on a without cause termination. The employer actually doesn't need to have a reason at all. You could be the best person in the world at your job, and they could get rid of you if they chose to. And it's not a wrongful dismissal just because they terminated you and it's unfair, um, or it feels unfair to you. It's a wrongful dismissal in the event that there is a failure to provide you with appropriate pay in lieu of notice or notice and severance and other entitlements. So basically, the wrongful part comes from the fact that you're not being compensated appropriately for the termination. Um, Even if you were to ask most employers what the reasons are for terminations, they often will just say we were restructuring or the position became redundant. Whether or not that's true, I'm sure it is sometimes, and I definitely doubt it is other times. Um, it does seem strange to me, and I agree with you that sort of seems disingenuous that you would have just received a performance review and a raise last week, um, and then are being terminated for not being a good fit. Um, Potentially, whoever expressed that to you doesn't really um, know the reason, and that just sort of became a standard answer. Um, it they are allowed to do it though. Certainly, they can terminate anyone at any time for any reason or no reason at all, um, without cause, so long as they're paid appropriately. So the real question at this point for you is, you can't challenge the termination in and of itself, but you can challenge the fact of the termination in regards to what your entitlements are for notice or pay in lieu of notice. So so the real question here for you is, what were you offered upon termination? You don't have to put it in the comments or anything, but what were you offered upon termination? Does that meet your legal entitlements? Are you potentially entitled to more? And if so, do you have an interest in possibly pursuing that? Um, that's a tough one because I understand that would have been extremely confusing, especially with the raise last week. Um, but it is possible that they could do it. Um, and the only time that they actually require that you're provided with a reason is if it's a for cause termination. So in a for cause termination, you're being terminated sort of at a fault of your own or alleged fault of your own. And because of that, because there's an accusation or allegation being made against you that's saying this was so severe and so significant and so serious that we're not going to pay you anything. Um, in those situations, they do have to provide you with a reason because you need to have something to defend. You need to be able to understand what your sort of breaches were, or what behaviors it is that they're alleging took place, that led to the termination. Um, so if you were only provided with 2 weeks after 3 years of service, um, I'm guessing that you haven't hit the full 3-year point yet, and that would be just your ESA minimums, whether you're in BC or Ontario. Um, but if just definitely don't sign anything. It may be worthwhile speaking to one of the lawyers at our firm about getting a consultation, and having them sort of look at the termination documents that you would have received, and let you know what else is possible, looking into your stats like your age, your length of service, your position, and the availability of similar work in the marketplace. All of those things kind of come into consideration. They'd also need to see your termination clause if you do have an employment contract that has one, to determine whether it's enforceable or not, so that we know whether we can break it, and in doing so, potentially, be able to sort of argue for additional notice under the common law. So if they're only paying you 2 weeks after 3 years and 3 months, then, they've breached the Employment Standards Act already, so I would certainly advise, contacting our office. Okay, everybody, I actually have to, we have to cut this a little short today, so, thank you so much for coming. It's lovely chatting with you, and, I hope that, any of you who, need some assistance can give us a call at the number on the screen, and we'd be happy to, book you in for a consultation so that you can find out more. If I express that your case sort of requires a little bit more one-on-one time, and you can also come back tomorrow if your question wasn't answered for another Q&A at uh, at 1 p.m. Eastern tomorrow. Okay, thanks so much.